evidence that is before this court in what is called the motion for fraud of the court. Your Honor has been provided with not only a notebook of cases, but the actual supplemental motion for fraud of the court and the previously filed notice of supplemental memorandum, which has a group of the cases in it. The memorandum itself goes through in extreme detail over some 89 pages and identifies each and every one of the specific problems that we assert support the fraud, the false statements, the false responses in requests for production, the false evidence in the answers to sworn interrogatories, the deposition testimony, and what you heard during this hearing. As you recall, this case is fundamentally about the collection of the 12 dolphins that Ocean World captured or collected, and the justifiable or unjustifiable interference with that relationship with the Dominican Republic. By way of review, our client secured the adoption or attempted to secure the adoption of these animals by contacting the museum in Japan and having them cull out 12 dolphins, and once they are captured and properly handled, an exportation license is provided, which allows those dolphins to be transferred to the Dominican Republic. Those dolphins must be captured in conformance with CITES, which we referenced to you as the Convention on International Trade of Endangered Species. Has to do with a group of countries that get together to control and make sure that animals and plants which are captured in a way that is humane and fair. In order to accomplish that, Japan must issue the exportation permit, which they did. This case is about the importation permits from the Dominican Republic that were denied as a result of the unjustified or tortious interference by the defendants in their communications that we've discussed throughout this hearing. Principally, it relates to representations made in various videos, which have been the subject of this discussion in the hearing, and various sworn testimony that was given. Your Honor has had an opportunity to see a good portion of the videos. There are more in evidence, but has seen the essence of what our case is about. This particular motion involves whether or not the defendants and or their counsel engaged in any kind of fraudulent activity or improper conduct in responding to various discovery requests and making certain representations about the validity of the videos and other things. In this particular case, we centered upon initially the discussion of the videos themselves and the actual request for production. As you may recall, there were specific requests for production that were sent out to the defendants that were quite specific and are enumerated in the memorandum in great detail. Most specifically, for purposes of this discussion, request for production number 3 had asked for videotapes that were relating to the complaint, the contractual or business relationships between the plaintiff and the Dominican Republic. It's important to understand as we go through these that these are very specific requests for production. They are pointed to the allegations in the complaint or to the contractual relationships that existed between them. In request for production number 6, we asked for videotapes and other types of video evidence that related to the subject of the claims that are being made here. That is the tortious interference and whether that interference was appropriate. Paragraph or request number 17 involving surveillance films or photographs regarding plaintiff's dolphins, using those exact words, plaintiff's dolphins. Paragraph number 26 was showing what data you have, videos, other types of things that show the interference with the relationships or regarding the plaintiff's dolphins. Request number 30 is regarding videos, compact discs regarding the plaintiff's dolphins, the contracts or relationships. Paragraph 31, the request for production, were also referenced the videotapes or other types of video evidence that is regarding the plaintiff's dolphins. The importance of this is to set forth several things. First, this was not a request for a computer dump, which has been earlier referenced. This was specific requests that were made for specific information. That information related to the complaint and our allegations that this particular group of defendants interfered with the contractual business relationships by going and actually playing the Medio videotape and showing it on television that did not depict the actual capture of the 12 dolphins. That's what this case is about. Either the video depicts the capture of the 12 dolphins or it doesn't. And what did they do? Did they give us all the information? Well, as set forth in the memorandum and throughout this proceeding, they held nothing back. In fact, if I was to refer to a specific reference, although I'm sure it's not needed, I would point to page 164 of the deposition of Mr. O'Berry, where he indicates that he held nothing back and he gave everything to the attorneys who gave it to us. Those constituted many of the videos that you have in evidence, some of them which were referred to by a name such as Welcome to Tajii or the Tajii 12, the ABC footage or YouTube footage, those kinds of colloquial names that were referenced. The interesting thing about that is that we're asking for production, particularly in this case, of the videos. Now, presumably, they would not give us irrelevant evidence. Presumably, they would not give us evidence that has nothing to do with this case. Evidence of videotapes of other areas that had nothing to do with the merits of this case. We have to presume that what they gave was truthful. At the time they gave it to us, they did in what is listed in Defendants 8 in evidence. They gave us a letter. It said, you know all these requests you have? We're giving you, Earth Island and the defendant O'Berry are giving you all these document numbers, including all the videotapes which are in evidence. We're giving that in response to these production requests. To the production requests.
Slow down. Sorry.
To the production requests, which relate specifically to the plaintiff's dolphins or the capture and collection of these 12 specific dolphins. There was no dispute about what they were giving us. There was no knowledge on our part as to whether that footage was accurate or not accurate. We are to presume that that footage is accurate and actually depicts what they claim that in the Medio program, that this was the collection of the dolphins. As you recall, and I'll mention later, specifically, Mr. O'Berry said, I took the photographs and collected these on one day, it occurred on one day in October. And he said, I have the absolute documentation, that's the words he used, the absolute evidence that this was evidence of the Tajii 12. As you may recall, when we were listening to the video of the Medio program, multiple times he was asked whether this was the original footage or whether this was some sort of archival or edited footage. You heard, absolutely not. This is the footage. And in fact, when you listen to the Welcome to Tajii video and some of the other videos, he specifically references that I can't edit this. You need to see this horrible thing in this one take that it is. There was never any indication at any time prior to the deposition testimony I'm about to speak about of O'Berry, where they said, let me let you know, we're giving you these videos, but they're not of the capture of the 12 dolphins. That they're not of the capture of 12 dolphins. They gave us these videos in response to our request for production. In interrogatories, Mr. O'Berry also swore under oath that all of this filming of the collection of 12 dolphins occurred in one day. Interrogatories, as we all know, are sworn under oath. To this day, there has never been a withdrawal of that. There has never been an amendment of that. There has never been a change of any kind. What did they do in response to our complaint that gave rise to our production requests? Well, they denied all the allegations and specifically raised a number of affirmative defenses. I won't itemize them all because they're all contained within the memorandum and in the complaint and the documents which you've taken judicial notice of, but they include defenses that are based on truth, fair reporting. This is an accurate depiction. All of this having to do with the collection of the 12 dolphins, because that's what this case is about. It's not about anything else. The answers and affirmative defenses have never been changed, have never been amended. They've never suggested, you know what, the stuff that we gave you that is part of the collection of the 12 dolphins really isn't footage of the 12 dolphins. It's really footage of something else. Well, how do we come upon and learn about the fact that, in fact, this evidence wasn't really accurate? Because what you heard during the hearing was as if we should know that this footage was old because they're now announcing that it's old. Well, how did we learn that the evidence really wasn't accurate? How we learned was Mr. O'Berry's sworn deposition testimony in November, where he admits, you know what, that video I gave you, it's not an accurate depiction. It's not true. In fact, let me go back just a minute and talk about his September depo first that leads up to this famous Friday the 13th, November 13th, 2009 depo. In September, a depo was taken, and there were many days of this depo, but one particular day was devoted to the actual collection of those dolphins. And Mr. O'Berry, in repeated testimony, and it's cited in the memorandum, over and over again said, I filmed all this, it occurred in one day, we captured all 12 dolphins on that day. Repeatedly, over and over again. He did not say, by the way, that footage is not really of the Tajii 12, it's really not even of Tajii, it's of Fudo and some other irrelevant activities that have nothing to do with our case. Now you wonder why would this video, why would this old footage be usable? Why would they edit that in? What's the point of it? Well, they don't have any other footage of a horrible slaughter. So what they have to do is prostitute the 1999 footage and put it in these old videos so that people will get upset and get angry. And then when the Medio footage is playing, they're telling the group that is sitting there and the radio audience and television audience, listen, this is a horrible slaughter. And Stefan Meister was involved in this. And while you're playing the actual footage from Fudo that has nothing to do, you're playing the actual footage from 1999. I heard a lot during this testimony about, well, there was a 2004 video, and you should know it's 2004, and they've repeatedly said it's 2004 content. Well, under oath, okay, in contradiction to both the council and their parties, under oath, Mr. O'Berry has admitted that this is not really even 2004 footage. And in fact, it's actually 1999 footage from a video called The Dolphin Defender, which is also in evidence. So even the representations that this is 2004 footage is an absolute lie, and it's a fraud on this court, because it actually is 1999 footage, which we discovered when we looked at the Dolphin Defender video. At no time, and I want to make this abundantly clear, at no time did the defendants ever provide us with a copy of the 1999 Dolphin Defender video in response to any discovery request. They provided us with videos which secretly contained this 1999 footage and was spliced in to give the audience in the Dominican Republic, the officers in the Dominican Republic, the belief system that actually this was occurring in 2006. It's interesting when you look at something.
If that was turned over, you're saying to the Dominican Republic people, why should it not be turned over to you?
It should have been turned over to us. What I'm saying is that they...
So, okay, all right, I understand that, but I want to be sure you understand your argument as to fraud on the court. For example, you give me 3 or 4 things. You talked about the actual footage of the capture, the quote about this being the actual footage of the capture when it was not, as you said. You mentioned that the reference to all 12 dolphins we captured in one day, when in truth, as you said, it was not. And this, and a number of other things. Now, I'm bringing this up because you've got limited time, but how is this different? What makes this of a quality that a jury should not hear it and make the decision, as opposed to me taking it out of the hands of the jury? In every case, in just about every case that's in front of the court, there are mistakes, there are falsehoods, there are things any number of things that come up, spurious statements of all types. Why should this be taken out of the hands of the jury? Why is this not something for the jury to decide?
The reason is because, Your Honor, the case law, which is really...
And that's the essential part of the argument. I mean, if you have more examples, fine.
I will give the examples, but the reason why I believe it's a fraud in the court, and then I'll get back to the case law, is because in the supplemental memorandum, as I raised to you, I have cited literally dozens and dozens of cases that deal with parties that make false representations in deposition testimony, false statements in interrogatory answers, which are sworn under oath, false responses in production. I even have a case.
Well, that's why I brought up this particular example. If this was something that you said was presented to the Dominican Republic people, why is it, and they give it to you in discovery, how is this part and parcel of a fraud on the court? It's not something they gave to me. It's not false testimony and deposition or something of that nature, where it's part and parcel of this trial. This occurred before the case went forward, before this case was filed, right? The giving of the video.
No.
No.
The
After
videos,
the case was filed.
the videos that came to us came to us as a result of the press production.
The actual event with Medio was before the...
Oh yes, that's what set up this case.
So if you're asked to give all videos involved in any manner, way, shape, or form, and then covers what was given to Medio, how is that a fraud on the court?
They did not give the 1999 Dolphin Defender video to Medio. They did not give the 1999 video to us, even though they represent...
But the representation was to me that Mr. O'Berry said this was the actual footage.
That's correct.
What he provided to Medio. Am I correct? This is the actual footage, and you're saying that's not true. And then this is provided to you. How is that a fraud on the court then? Let me ask you that one.
What happened was, the reason why it's a fraud on the court is because we asked for documents. We get back documents saying this is the capture of the 12. This relates to the plaintiff's complaint. This relates to the specific plaintiff's dolphins. The actual phrase, plaintiff's dolphins. And they give us footage, which is not the plaintiff's dolphins. You can't do that. The case law says you can't give me false evidence or splice together evidence you don't give me and say that it's evidence that's responsive to the court.
Yeah, but in terms of that particular thing, this was the footage, false or not, that was provided to Medio, right?
The footage that was provided to Medio, I'm sorry, I misunderstood your question again.
You quoted Mr. O'Berry saying this was the actual footage of the capture on the TV show, correct?
Yes.
On the TV show.
Yes.
Now, let's say he misled them. Let's say everything you say is absolutely true, and you're asked to turn over that video in discovery. How is that part and parcel of a fraud on the court?
Because I asked them to, Bruce, let me go back just a minute, maybe I can help. In response to the complaint, they not only deny allegations, but they say their conduct, that is, their conduct in showing videos to Medio in the content, is true. What they say in response is true. Okay, so we asked them...
That's not what I asked, but now I see what you're saying. If they confirm during the trial that this is the actual footage, if they repeat that's something different than what I'm asking you. Are you saying that since it was turned over to you, they again said, either under oath or admissions or something, that this is the actual video footage of the capture of the 12 dolphins?
Yes. I'm saying to you both. I'm saying to you first that they filed an answer to affirmative defenses claiming truth. And we asked them, give us the support for why you believe it's true. And they give us videos which are not true. After that, Mr. Penalta took the deposition of Mr. O'Berry and spent all this time in September asking him, is this the actual footage? And Mr. O'Berry is saying, yes, I did it all in one day. This is the actual footage. That is what is clear in terms of their false statements. Now, after that time, in September, in November, when Mr. Penalta gets all the evidence together and starts cross-examining Mr. O'Berry at later depositions, he starts to admit, you know what? It's not. It really isn't that footage. It might have been other footage. It might have been the same footage. Okay? So Mr. O'Berry himself is hoisted by his own petard. He's already admitted because he realized that Mr. Penalta had the goods on him. He realized that now we have false statements. So the reason why we have a fraud is because they're responding in discovery with videos. They're saying these videos are a true capture. They're not a true capture. And the test is not whether or not they give you evidence. The test is whether during the course of litigation, do they provide fraudulent or false conduct in responses to production, in sworn testimony, in depositions, or in hearing in front of the court that supports a fraud of the court. And this goes to the essence of the case.
You're saying, though, eventually in discovery he corrected his errors?
Eventually in discovery, he admitted he lied. I would agree that he confessed. Once he was cross-examined, he confessed. But I'm not finished, because even though he confessed, he then later on in the deposition goes back and says the opposite again. And says, oh, no, yeah, it was the footage. And you have to read the deposition in context to see, and we cited the references not only in the memorandum, the 90-page memorandum, but also we put his depots in evidence so you could see the specific depositions that show him contradicting himself on multiple occasions. To this day, okay, they have never produced the 1999 footage. So they're claiming, hey, this is 2004 footage. And now they're giving us 1999 footage and not telling us. as if we're supposed to think that it's the 2006 footage. And when you read his depo, he suggests that it's the 2006 footage, that all of this footage that's being given is the 2006
You
footage.
have 2 minutes left.
Okay.
I'm going to make it 5 because I asked you a couple questions. Then we'll take a 2-minute break so I can sign this order.
What we have shown is that the Tajii 12 is not the video of the collection of the Tajii 12. We have shown that the Welcome to Tajii is not even really footage of Tajii, but it's actually the majority of footage of Bukfuto. We have shown that Mr. O'Berry and the defendants, Earth Island Institute, as well as whoever participated in producing that information, produced false and fraudulent information in the intent to have everyone believe, including the people at Medio Medio, which they did, that this was 2006, the collection of the 12 dolphins. That's an absolute false and fabrication. Now, just to mention the cases, and then I can come back to them if the court needs more. There are a number of cases that are cited in my supplemental memorandum, which I would ask the court to take a look at because it actually summarizes the holdings.
Are they in this loose leaf you gave me?
I'm sorry?
Are they in this loose leaf?
There's an attachment. The cases that are cited in the memorandum are in that loose leaf, but if you look at the memorandum, it actually just makes it easy and cites to you, the cases, and then gives parentheticals of each one of the holdings of the cases, so that Your Honor can approach it if you don't have that copy.
I have that here, don't I?
You should.
Well, so I have plaintiff's notice of findings, certified translation of any radio broadcast, filing supplemental memorandum, notice of filing supplemental memorandum in support of awarding sanctions for fraud.
Yes.
And is that
See that one? That you just.
And I have one in the loose leaf. Another one.
Yes. If I may approach.
Is that what this is right here?
Yes. I just want to make sure.
I'm going to get schizophrenic. 2 loose leaves with the same thing in it.
If you'll
I
see.
assume they're the same, right?
Yes, sir. You'll see that in that memorandum, we actually cite a number of cases, and most of the cases are dealing with much more heinous sanctions than we're asking here. In that case, many of these cases, you're dealing with actual dismissals of entire plaintiff's actions for lies in deposition, lies about injuries, fundamental lies which don't hold a candle to what's going on here. Sorry?
Are you citing the cases? Or
Yeah. If you look to the
or you
cases,
supplied the cases?
because of the timing, if you look on page 2 and 3 and 4, you'll see that I list, and in the footnote, I list a group of cases, cite them, put the parentheticals to them, so that you would have a number of cases. Sure. Is that the beginning of the big book?
The big book
Oh, the
is,
big- all right,
the
the
big
big
book
one.
is what he's referring to now.
Oh, that's not what
the
he-
notice
no,
of
no,
filing.
Not the cases, the actual memorandum. Let me just give you one.
Chris, too.
I have the memorandum. I said, these are the cases that you cite?
That are in here. What I did was we filed this memorandum back in February. Yes, and in that memorandum, if you look on pages, 2, 3, 3 that you're on, you'll see in the memorandum, in the footnote, it cites to many, many cases that are supporting the
These are
proposition.
the cases themselves?
Correct.
Oh,
That's
what
correct.
I wanted to show you.
Yeah, I'm sorry, Your Honor. I'm sorry. And just to bring it more current before I close, there's actually a case which I provided a copy to opposing counsel, but if I didn't, I'll give you an extra one that I gave to Your Honor, which is called the Trammell case, where they actually struck the defendant's pleadings for improprieties related to the way in which they created the videotape. And the court found it was appropriate to strike the defendants and or to enter judgment in favor of the plaintiffs. And what we're asking for is the striking of the pleadings, the award of attorney's fees from the time of the motion filing and anything before or during that related to having to uncover this fraud. I realize that I'm running out of time, but I would stand on the memorandum, which is also filed, which details the actual allegations, because under the law in Florida, you would need to make evidentiary findings in the record, and if you wanted to, you could adopt this entire memorandum because it breaks down each and every interrogatory or any part of that.
Which memorandum is that?
That's the one that's in the smaller notebook, Your Honor,
Give me a lot.
that says plaintiff supplemental. It's a smaller notebook.
What happened to it? I just had it. Did I give it back to you, Winston?
If you did, I can certainly provide you with.
No, that's this won't come out of your time. What? How do you do that? Where did I just had it.
For convenience, should I provide it to you again?
I'm glad this isn't done. Yes.
What the supplemental memorandum does, Your Honor, is it articulates, as you get, for example, starting on page 8, it will articulate what are the answers and affirmative defenses that show fraud. What are the interrogatory answers that are false and misleading? What are the production responses? It effectively just redetails what I've summarized here today and throughout this proceeding. But because there's some findings that the court may be required to make, we provided in detail, each and every production request so that Your Honor would be able to select any or all of them that would be consistent with what we've been trying to prove throughout these times in the hearing. For those reasons, we'd ask that this court grant them motion for fraud of the court, make a finding that there were false statements or misrepresentations that were made, a finding that should result in a fraud of the court because they intentionally and essentially set into motion something that hampered the ability of us to function. We had to spend.
Don't conclude now. You still got another 10 minutes.
Okay. Then I'll rest and stand for the rest.
Let me just sign this order on this other matter.
Can I move the podium while you do that?
Yes.